Welcome to Dementia-Friendly Prince George's County, Maryland Northern Sector webinar series for caregivers. Today's topic is the art of estate planning, sponsored by Prince George's County Government and the Department of Family Services.
I am an estate planning attorney. I've had I sometimes I just like to stop it at 30, but more than actually 30 years of experience in estate planning, elder law. Our office is in College Park, Maryland. And this book was a long time in the making, and it covers so much of the experience that I've acquired in this field that I love passionately. So the okay, I okay there. This book is dedicated to my husband, Lonnie P. Henderson, and to my father, Clinton W. Chapman. And I have a couple of things I want to say before going forward. One is that I have done this work for so many years, but I never had the experience of being a caregiver. Well, that experience was given to me within the last 2 months when my husband developed um, some very disabling symptoms. And so I had the experience of being a caregiver. By God's grace, that experience is complete, and it ended. He's recovered, and I'm grateful for that. Um, but it also gave me firsthand what it means, what how life can throw different twists and turns suddenly. And the other person, my father, he has been a wonderful father in my life, and I wanted to mention him. He's not only been a wonderful father, but he's been a mentor, and he was the reason that I went into law because of him. He is a lawyer, and I just wanted to just share this brief story. He's modeled so much for me. He's modeled how to age well, among all the other things. But over this season of his life, he's modeled how to age well. And I had the privilege of spending time with him on Sunday, Father's Day, and we spent time talking. He had seen his other daughters. He has three daughters. He had talked to and seen his grandchildren. And at 96, he was making plans to go. We were talking about his plans to go down to South Carolina for a train excursion. He hadn't, as much as he's traveled around the world, he hadn't done that kind of traveling. And so he wanted to get that in. He and I were working on a case, one of his cases he enlisted my help on. Yes. Did I tell you he was 96? He's 96, still very active, still very involved. And as I said, he models for me what it means to age well. He was in good health. And so I had a wonderful experience with him on Sunday. On Monday, I learned that he departed and uh, just just slipped on away. Not sick, he just departed. And he has modeled for me what it means to leave the body in a way that is just very, very comforting. So I just wanted to share that to you for you. Um, and I want to dedicate this presentation to my father, Clinton W. Chapman. So um, that's what I wanted to say. Okay, all right. So the book, The Art of Estate Planning, is a practical guide to get you from where you are to where you want to be in estate planning. It helps you to move past the hindrances to estate planning to having a fully developed and satisfying estate plan. And it doesn't matter whether you're starting from scratch or whether you have an existing plan that needs updating. It will get you to where you are, to where you want to be. And so I wanted to I'm going to take this time to talk to you about really the beginning of the book, some of the concepts that you'll encounter. The book is written in a way that is very readable. Everybody tells me it's readable, and it makes a lot of sense. So the first thing we're going to talk about is the art of estate planning. What does that mean? And the second is um, what is estate planning? We always talk about estate planning, but rarely do we really talk about what it really is. So I'm going to talk about that. I'm going to talk about your authority. That's a that's a significant concept. Your authority, and then if you have not exercised your authority and become incapacitated, what happens? And if you didn't designate anyone, which means you didn't exercise your authority in estate planning, you're likely to end up in guardianship. So we're going to talk about the consequences of incapacity and guardianships because I think it's important to know what can take place if you don't act. Um, we're going to talk about the steps to moving forward in estate planning, how we can get you moving, and then just give you a taste of what remains for you in the Art of Estate Planning book. So, with that, what is estate planning? Um, if you understand, if you grasp these three principles, you've got all you need to know about what it means to estate plan. Um, so first, estate planning is about planning, right? Putting a plan in place. So the first component of estate planning is a plan for who handles your affairs and how they handle your affairs if you can't. So you're gonna what you're looking at is who's going to keep your life going forward if you can't. So you're still alive, but you no longer have the capacity to make decisions. And not only who's going to do it, or there may be more than one person, and often it is, but how they are going to do it. You can put plans in place to guide them into how to make decisions for you if you cannot. The second component of estate planning is a plan for your loved ones and your assets after you pass. Most of us are used to someone saying, I'm giving my house to my spouse, I'm giving X amount of dollars to each one of my children. There are all kinds of different ways of doing it. But the point is, do you have a plan for disposing of your assets and actually for having someone step up and handle your affairs after you're gone? And we'll take a look at that there are lots of ways in which you can dispose of assets that make it convenient and cost effective, which leads me to the third point, and that is that your estate planning should include a plan for minimizing taxes, costs, time, and pain and mess. Now, pain and mess, you see, I have it capitalized, underlined. Pain and mess is a big thing, is a big factor that you want to plan against because that's what's going to hurt the most in your for those whom you leave behind, or if you become incapacitated, those of your loved ones who are trying to help you. It can be a real burden if you haven't planned. Um, um, the book has many stories of the pain and mess that has been caused because someone either didn't plan or had an ineffective plan in place. One, for example, was a woman whose body laid in the morgue for weeks and weeks and weeks and weeks, even because there was no money to bury her. And despite the fact that she had $100,000 insurance policy, the plan and that policy just didn't fit because there's some things that she didn't do. We wouldn't want to have that happen to any one of our loved ones, at least as well. We wouldn't want it to happen to us. There's also the pain and mess caused by the family who thought they were avoiding probate, but because the plan was defective, what could have been a $3,000 settlement or finalization of the estate cost over $30,000. Don't want that. And what about situations where you there are people you don't want to have in your estate, you don't want to benefit, but yay, lo and behold, because the plan didn't work, they're there. Or the loved one who you would want to benefit, but because the plan didn't work, they don't get what you had intended for them. So think about, look at those three, making sure you have a plan in place if you become incapacitated, making sure you have a plan in place for what happens to your resources after you're gone, and then minimizing so you don't have the stuff left behind that can be so hurtful for your loved ones. All right. All right. Let's see. So I'm going to talk about authority. Authority is such a significant concept. Authority is your ability to establish a plan and have it enforced. Now, I have that image of the traffic cop who does an excellent job of bringing traffic to a halt, regardless of the conditions or the time of day. He's just standing there and using his arms. Um, he can stop an 18 wheeler, um, anything of any magnitude. And how does he do it? It's not because he has the physical strength to stop the traffic, but because of his authority. And it's the authority that he has that causes this the authority backed by the state that he has that causes drivers to halt. So likewise, with your plan, you have um, authority where if you put a plan in place, you have the authority to make sure that it works when you're not even working. You have a plan that you can put in place that you can rest assured that it will be carried out if you're incapacitated or upon your death. You're not working. Okay. So we want to encourage you to use your authority. And so you can be confident that your plan can be carried out if you do these three things. One, know your authority, the ability for you to put plans in place so that they are enforceable. Most of us, and I say you because that's what I do, most of you don't know the extent of your authority. And that's what we do as estate planning attorneys, help you to understand the extent and the breadth of your authority. You can do far more in estate planning than you know how. The second is to exercise your authority. And you exercise your authority by making sound estate planning decisions. Again, a good estate planning attorney, good estate planning counsel will help you do that. And thirdly, put it in appropriate writing. The estate planning is all about what is in writing, not about what your intentions are, but what is put in writing and put in the appropriate form so that it can be enforced. So those are the three keys to making sure you have a plan that you can rest assured is going to work. Okay. Next, so we talked about authority. Authority stands. You can't exercise your authority without capacity or without the ability to make legal decisions. And I wanted to let you know what the consequences are of not having legal capacity and not having a plan in place. So, legal capacity encompasses your authority to make decisions about yourself and your property and your finances. And we are presumed to have legal capacity unless otherwise determined. If you lack legal capacity, then you are likely to be set up for guardianship. Some of you may have been reading in the uh, uh, news about Britney Spears, a young woman, and she's usually you don't have people that young and that active, vibrant, involved, engaged in guardianship. And she is now becoming a spokesperson for some of the perils of guardianship. But um, um, there are 12 things I want you to know about guardianship. But before I do that, I want to say that what I wanted to explain what guardianship is. Guardianship is a legal process where the court will has to make a decision that you are legally incapacitated. You cannot make your own decisions. And the court, if they make that decision, then you literally become a ward of the state. The court can also make decisions about your property. And if the court determines that you do not have the capacity to manage your property, then again, your property becomes under the control of the state. And so with guardianship, you come under court control. If the court determines that you need guardianship of yourself, and by the way, the term guardianship usually it can deal with you and your property. In some states, guardianship deals exclusively with you, and conservatorship deals with your property. But in any event, if the court has determined that you need legal guardianship, you come under the court's control. You literally become a ward of the state. And as such, you often lose your freedom of choice. I was just reading Britney Spears saying that she felt as if she had to work. She didn't have any choice about it. There are some real restrictions to what you can and cannot do in guardianship. The court selects your guardian. Even though the person closest to you may seek appointment, and even though that person becomes your guardian, it's only because the court has decided. Guardianship is costly. It is costly. Not only are you paying, not only are you paying for the process of opening guardianship and all that entails, but the cost continues as long as you are under legal guardianship. Guardianships are public, so it's no private matter, and lots of what's going on in your life becomes public knowledge. If you're married, your spouse's rights can also be affected. Not it very likely is. Guardianship often lasts until your death. Most people, once they determine in need of guardianship, that's a lifetime engagement. Older adults are at a greater risk for guardianship. Older adults generally have more health issues that render them incapacitated and unable to manage their affairs. Guardianship is usually required to manage inheritances left to minor children. Guardianship is it's called living probate. Some of you are familiar with probate. Um, Probate has to deal with dealing with assets after death. Guardianship has to do with dealing with the person and that person's assets while they're living, and that's why it's called living probate. One thing I want you to be very, 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 very clear about is that most guardianships can be avoided by proper and timely planning. In my opinion, there's only a very small role for guardianships for adults, and that is one where there's just no one to make decisions for that person, no one who is qualified. And in all my years in practice, I've only met one person who was wanting to leave things for her special needs daughter, and she had no one that she was confident in, and she wanted to have um, her daughter go through guardianship when she passed. And that was the only case where I had to concede that that would be appropriate. My practice is design, and all that we do is to help our clients avoid guardianship because of all of the restraints, the cost. Um, it is something that we don't want to see for our clients. Um, the other time guardianships may be necessary is where there is a broken family and the children are there's a lot of infighting. I say children, but usually it's with children. There's a lot of infighting among the nearest persons nearest to you, and the court can't sort it out, and they will appoint a guardian. And oftentimes, it's not the closest family member. The court will usually appoint someone like me, a lawyer, to come in and make decisions for that ward. And that is not something that you would want for yourself or for your loved ones, where anyone is coming in making um, global decisions, particularly when that person doesn't even have a relationship with the ward. So those things I want you to know, because most go back to 11. Most guardianships can be avoided by proper and timely planning. All right. So I said that this um, book is designed to help you move forward in estate planning, whether you are starting from scratch or you've got a plan in place. One of the things that we want you to understand is estate planning is a process. You don't stop just because on June 20, the day's the 24th, June 24th, you implemented a plan and you're comfortable with it, you like it. Um, there's June 24th, 2022, June 24th, 2023. Time goes on, things change, you change, people change, laws change. So I want you to understand estate planning is a process, and you will review your plan, and many times you'll be making changes. We have so many people reaching out to us during this COVID, wanting to make changes to their plan. Um, so, moving forward, 70% of Americans don't have wills, and even a greater number don't have powers of attorney. Why? Procrastination. So, why do most people procrastinate? Not because they are afraid of dying. A lot of people think that people don't want to do it, don't want to do a will, for example, because they're afraid that if they do a will, they die. No, um, um, it's really because they don't know how to get started. Most people don't know how to get started in the process. This is called inertia. People get stuck because they don't know what to do. This book is designed to help you learn what to do and move forward. So here's a couple of tips, several tips that I wanted to bring up or talk to you about now. One is to commit to take action now. Now is the time. Um, I said I had a story about my husband. Um, as I said, he well, actually it was a pretty rapid onset of this condition, and at some point he really um, wasn't able to um, remember lots of things, and I was grateful that he had a power of attorney in place, but there were things that I just didn't have access to because he didn't remember. And I kept thinking, I didn't get access to um, uh, passwords and so forth and so on. He has written books, and I was concerned that I couldn't get into the computer. I'd be locked out forever. Um, uh, uh, just a lot of things because it was so sudden. That's why it's important to take action now. By God's grace, he's recovered and is doing very well and recovered his memory, but doesn't always have to be that way. There are many people who um, do suffer conditions where they lose their capacity to remember, um, uh, to lose their ability to make decisions, and that's why it's important to act now. Get these plans in place now. Make a commitment. And so, okay, so you just don't say, okay, I'm making a commitment today. You've got to do some underpinning to gird yourself up to move forward. So one of the ways you can do that is to understand why estate planning is important. Um, you can do that by attending workshops, by doing reading. Getting this book is one way to understand why estate planning is so important. But not just important on a general in a general way, but why it is important to you. And so the book helps you to uncover that. Um, Learn some of what you don't know. Again, inertia. It is the ability to move forward because we just don't know what to do. So learn some of what you don't know. And fourth, consider something. Consider these three things. This also helps you to understand your why. And one is, who are the people in your life whom you trust? Who are the people in your life that you would be willing to turn some of your affairs over to? Who are the people that if you had to close your eyes yesterday and uh, you needed someone to manage your estate, distribute assets according to the way you want them to be distributed, who would those people be? If you were still living but could not make your own decisions, who would those people be that you would entrust your authority to? So your trusted ones. It doesn't have to be a lot of people. And many times I find it may be just a couple. It may be a couple, or it may be husband and wife, or close friends, and they don't have a whole. They just don't have a huge. I call it a pool of people. That's all right. That's a starting point, and that gets you moving forward. Also, consider who you want to benefit from what you have spent a lifetime accumulating. Who would be your beneficiaries? How would you want them to? What? How would their lives be different from what you left? Um, how can you make life better for them? These are the things you can be thinking about. And then think about what you have. Most people don't really know the full scope of what they have until they start putting pen to paper. Oh, I've got this account here, I've got that account there. Um, I've got the 401k. Um, um, And it may be that you think, I don't really have that much. No, 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 no. Even if you think you don't have that much, you have enough that and you have enough to consider who you want to benefit. Um, if you um, if you look at these three and just be thoughtful about it, that's going to help you. That's going to help you move forward. Help you move forward. Again, we have some tools in the book to help you uncover these things. So, um, yeah, consider those three things. And let's see. So, I talked about the only a very small portion of the book. We want to get you moving. I want to give you a taste of what remains for you when you get the book. It you can get it helps you get motivated and get moving. Now, identifying the right attorney for you. We're all different people, and we have different requirements. The book talks about how to identify the right attorney. What about understanding what planning can do for you and your loved ones? Again, that helps with the why. So we help you understand what you can do with an estate plan. We talk about the 7 estate planning tools everyone should consider. They include the powers of attorney, the advance directives, the HIPAA authorization. They include um, um, your will, your trust, your transfer on death, beneficiary designations, and the ownership. That means that that um, provides for the surviving owner to receive the benefit. So we talk about those tools. We talk about what they do, what they don't do, and how they work and don't work. You know, estate planning in some ways can be like a puzzle, uh, piecing the individual pieces together. Um, Going back to the right attorney, I just want to make sure that I caution you. We can get so much off of the internet, but in all of my experience, in my experience as an estate planning attorney, you can't get the satisfying plan in place without good counsel. Very, very seldom have I seen a good plan work where there was no counsel. Okay, so we talked about the 7 tools, and we talk about it in detail. We talk about the hidden truth few people talk about with respect to estate planning and the impact of this hidden truth on your planning. So we talk about that. Trust. Everybody wants to know about trust, how they work. We give you a good working knowledge so that you can take with you the understanding of trust anywhere you go. Okay. Um, we also talk about advanced estate planning concepts that you need to know. And you know, just talking in generalities and in principles, that's not enough. And so there are plenty of real life stories that you can relate to, and you can see, like the woman in the morgue. Um, Oftentimes people ask, well, uh, how much do you need to do a trust? I said, you know what? It's not a matter of how much, what you have. It's a matter of what your objectives are and who you want to benefit. And the book tells a story of my client who was indigent, and she came to me through one of the organizations where we provide legal services to whom they refer at very little or no cost. And so her only asset was a $40,000 term policy. 40,000 term. And she We talked about what she needed. She had a daughter who was a special needs person, and she had a son on drugs. And she didn't want for her daughter to lose her benefits, and she didn't want her son to take whatever he got and blow it on drugs or perhaps kill himself. So we looked at how a trust could prevent both, and she was willing to pay. But in her case, it was extra money, but she was able to pay, and she was willing to pay for a trust for her daughter and her son. Um, and there's more in there for you. Take away. So I want to remind you again that good estate planning requires good counsel to accomplish your goals. So don't try to do this yourself. This is not a do-it-yourself project. Estate planning is very complex, um, and there are pitfalls that if you don't know what you don't know, you can be in trouble. So we encourage you to have counsel, good counsel. How do you get a? Oh, let's see. One thing else I wanted to say, we have live educational workshops to reinforce the art of estate planning. Um, we now do workshops remotely. You can get them we do them on Zoom. We have workshops the first and the third Tuesday of the month. On the first Tuesday, it's at 1:30. The third Tuesday, it's at 4:30. And if you come through the workshop, you can get a complimentary consultation with me or one of the attorneys who work with it in the firm. So consider going to a workshop, and you can do that by going to our website, www.hendersonlawforgod.com, and registering, or simply calling our office 301-220-4463, and we'd be happy to welcome you at one of our workshops. And finally, how do you get a copy of the book? Well, you can get it, I always say, wherever good books are sold. You can also get it on Amazon or any other of the other online retail sellers. The book is very reasonably priced, and I urge you to get a copy for yourself and get a copy to give to one of your loved ones.